So,
but Ms. Blatt, Mr. Stewart suggests that all of those kinds of questions in terms of the extent of liability for this kind of organization would be addressed in the context of liability, not, by that I mean each state, when somebody tried to claim that YouTube had done something improper in terms of pulling up those kinds of videos, that each state would then look and determine based on their own, common law, whether or not you were liable. And he posits that that wouldn't happen very often, but we don't know. My question is, isn't there something different to what Congress was trying to do with 230? Isn't it true that that statute had a more narrow scope of immunity than courts have, ultimately interpreted it to have, and that what YouTube is arguing here today, and that it really was just about making sure that your platform and other platforms weren't disincentivized to block and screen and remove offensive content. And so to the extent that the question today is, well, can we be sued for making recommendations, that's just not something the statute was directed to.
So can I take this in two parts? Because I feel like your first part of your question is addressing what the dispute is between the parties, and the second part of your question goes much deeper, and which is beyond the question presented. But just on your first question about why do you need an immunity as opposed to liability? And in our view, that's like saying, that's death by 1,000 cuts, and the internet would have never gotten off the ground if anybody could sue every time, and it was left up to 50 states' negligence regime. And let me give you an example. A website could put something alphabetical in terms of reviews, and every young Williams and Zimmerman, i.e. XYZ, could say, well, that was negligent because you should have rated it somewhere else.
No, I totally understand that, but I think my things are not actually different. What I'm saying is that problem that you identify, which is a real problem, the internet never would have gotten off the ground if everybody would have sued, was not what Congress was concerned about at the time it enacted this statute.
Well, so that's correct. That's incorrect for a number of reasons, and we can talk about what two choices you're talking about. There's only two arguments on the table for what you could think that C1 does, and that is it simply says, no interactive computer service shall be treated as a publisher. And you could think, well, there are two ways of looking at that. One is that you need an external law that has publication as an element. And then second, which I think that your question may be going to, is it only directed to eliminating forms of strict liability across all causes of action? And so both of those ways are highly problematic and also inaccurate given what was happening in 1996. In terms of just looking at this as, is this just talking about defamation? It plainly can't be, because the statute would be a dead letter upon inception, because any defamation cause of action can be repled as negligence or intentional infliction of emotional distress. So we think the word treat, which means to regard, applies whenever the claim is treating the or imposing liability because by virtue of publishing. In other words,
but what do you do with the title and the content and the context? Right? The title of Section 230 is Protection for Private Blocking and Screening of Offensive Material.
So let me just pinpoint then the second one, which hopefully we'll get to on Section E, which is all the exceptions. But in terms of the title, Stratton, Oakmont, and restrictions, C1 and C2 are a pair. So what you have is C2 is, and they work together. And if every time you weaken C1, you make C2 useless and defeats the whole point of the statute, at least in terms of cleaning up the internet. C2 is just a safe harbor and directs what happens when you take stuff down. It says nothing about what happens to the content that's left up. And so the more any website removes material, it perversely is showing that it has knowledge or should have known or could have known about the content that was left up. And so you have one of two things happen that would happen and would have happened then and would happen now. The first is websites just won't take down content, and that just defeats it the whole point. And you basically have the internet of filth, violence, hate speech, and everything else that's not attractive. And the second thing, which I think a lot of the briefs are worried about in terms of free speech, is you have websites taking everything down and leaving up basically you take down anything that anyone might object to, and then you basically have, and I'm speaking figuratively and not literally, but you have the Truman Show versus a horror show. You have only anodyne, cartoon-like stuff that's very happy talk, and otherwise you just have garbage on the internet. And Congress would not have achieved its purpose of, and remember, it had, in all those findings, only 3 of which are addressing the harmful content. Most of it is dealing with having free speech flourish on the internet, jumpstarting a new industry, and it's inconceivable that any website would have started in, one lawsuit freaked out the Congress. And
Ms. Blatt?
Yes, sorry.
Just